Hello, Secure Transactions class. Good to see you all again. Thank you for sending in your outlines. Again, I really appreciate all the work you're doing, engaging with the code, struggling with it, trying to figure it out on your own. It's really the best way to learn the UCC. And it's a great exercise in statutory interpretation. And so I'm impressed by the work you're doing, and thanks for getting that in on time. And now I am going to give my video response and work through these problems together with you. And I'm so happy to finally get to this, because now we're finally kind of completing the picture of secured transactions by getting to the priority rules, because there's so many preliminary concepts that you need to master. I'll go through them again. You know them well. Remember when we first faced the classification of collateral and learning what accounts were, and instruments, and goods, and inventory, and equipment, general intangibles, payment intangibles. I want you to still think back and make sure that all of those things that I just mentioned to you, you have a clear understanding of what they mean. And if you don't, come and talk to me, and I will, in the space of 5 minutes, lay it all out for you. It's not rocket science. But it's important that you have a familiarity and a comfort with those things. And I know that's a lot of technical stuff, and I don't want to assume that it's easy to master. I remember when I first faced it, I didn't understand what a general intangible was. It was hard to wrap my mind around. And so, don't be shy to come and say, what is that, Professor Sundahl? Can you please elucidate? And I will. So, classification of collateral, attachment, the mechanics of filing a financing statement, other ways of perfection, such as possession. We haven't talked much about control yet, but we will. And now we complete the picture by really getting to the heart of secured transactions. Once you're able to figure out what the collateral is and how to perfect the heart of secured transactions, are then those priority rules, because that's what secured transactions at the end of the day is all about, is priority. Who wins the contest? You have competing claimants who want the assets, want to sell the assets and keep the proceeds, as you'll see when we get to enforcement. The secured parties don't generally take ownership of the assets. They just have the right to sell them and maintain the proceeds. But the priority, who wins the contest, that's at the end of the day what secured transactions is all about. And so the priority rules are at the heart of this game. And to determine which priority rules apply requires that you identify the parties, because that's really what the priority, the applicable priority rule depends on who the parties are. Is it a secured party? Is it an unsecured party? Is it a lien creditor? Is it a buyer? Is it a trustee in bankruptcy? If you can identify as a purchase money secured party. These are all different types of parties involved in a secured transaction. So that's another part of the field that you need to master, is to identify the type of party that you're dealing with. And so you have to know whether someone is properly perfected or not. So are they secured, or have they attached or not? So are they secured, or are they unsecured? Are they perfected secured, or are they unperfected secured? Are they a purchase money secured party? Are they a buyer? Are they a buyer in ordinary course of business? And I'll talk more about that. So identifying the type of party that you're dealing, that are involved in this contest, is essential. So keep that in mind, and we'll continue to hit that note as we go through the course. But then once you know who the parties are involved in the contest, then you apply the proper priority rule, and that's what we're getting into today. And so we're rounding out this picture. And let's just start with, jump into problem 62. And by the way, greetings from Toronto. I hope not to be traveling anymore in the near future. It's been Oxford, Montreal, DC, Toronto. It's been a grand tour, but as you see, as you become international business lawyers, travel is wonderful, but exhausting at the end of the day. I won't say anymore. I won't complain. I have a wonderful life, but it's hard to be apart from you guys. I love to engage with you in the classroom, and I look forward to doing that on Tuesday. Problem 62. So, this Epstein's bookstore, this is the debtor, this is a business. Epstein's bookstore, there are rarely any bookstores anymore at all, but here's one. They needed money, and they borrowed $10,000 from Octopus National Bank. Frightening name. Signing a security agreement giving the bank a floating lien over the store's inventory, and this idea of a floating lien. You should know what that is, because people talk about it. A floating lien. What is that? And that's a lien that kind of floats above all of the assets of the company, but what it means at the end of the day is that it applies to after acquired collateral. So it kind of floats above the operations of the debtor, and as the debtor acquires collateral, and it may be inventory or accounts receivable, the security interest will attach to those assets. And that's done simply by entering into a security agreement, attaching to particular inventory or accounts receivable or equipment, and then including that phrase, whether existing or hereinafter acquired. Archaic language, but that's the kind of language you see. And so it floats over the operations, and as new collateral is acquired by the company, it will attach to it. But remember, when you're dealing with inventory or accounts receivable, it's not necessary in the eyes of most courts to include that hereinafter acquired language, because it's just assumed, it's read into the security agreement that when you're talking about inventory and accounts receivable, that you're going to be talking about not only the existing accounts receivable and inventory, but also the hereinafter acquired, because inventory is always being turned around, bought and sold, bought and sold, bought and sold, and accounts receivable as well. They're also being generated when you sell something on credit and then paid off, and then generated and paid off, and so there's always the new collateral disappearing and reacquiring new collateral, and so on and so forth. But as a practitioner, you don't want to leave it into the hands of the court to decide whether or not to read that into a contract. Just put it in there that when you're dealing with inventory or accounts receivable or whatever else, it's going to be existing and hereinafter required. Okay, so that's a floating lien. So Epstein borrowed $10,000 from Octopus National Bank, and they signed a security agreement. Okay, that's one element of attachment over inventory. And then Octopus, due to negligence, probably malpractice, never got around to filing the financing statement. Okay, so they're unperfected. Martin's Travel Service was an unpaid creditor of the bookstore that sued on the debt and recovered a judgment against the store. Then had the sheriff levy on the inventory, right? And that's how you transfer the judgment into this writ of execution if it's unpaid, so you can just go after the assets of the company. ONB learned of this and calls you. And you're ONB's attorney. Does ONB or Martin's Travel Service get paid first when the inventory is sold? Okay. So this is a contest between an unperfected secured party and a lien creditor. Because that's what Martin's Travel Service is they have some other claim on the property. And it can be, I've talked about it before, it could be a tort claim, like a company, the debtor's truck runs over someone and they're broken legs or in a wheelchair, a tragic situation, and They win their tort claim against the company, and it goes unpaid. And so they convert it into this writ of execution and go after the assets of the company. But it can also be a contract claim. Just that this, so Martin's Travel Service was providing, God knows what, sending maybe the employees of the bookstore to international rare book collection shows, and garnering thousands of dollars of travel expenses, and then it goes unpaid. It's just a contract claim, and then they take it to court, and they get the judgment by the judge, and then it goes unpaid, and so they convert it into this writ of execution to go after the assets. So those are the, see, now we're determining the claimants in this competition. We have a lien creditor, someone with a judgment claim against the debtor, and a secured party. And it is a secured party, Octopus National Bank, because the three elements of attachment are satisfied. They gave value, gave $10,000. Debtor has rights in the collateral, the inventory, and they signed a security agreement, so it's attached. But they didn't file a financing statement, so it's unperfected. We have an unperfected secured party versus a lien creditor. And then the question is, who wins? If you have a contest over collateral between a lien creditor and an unperfected secured party, who wins? And the answer is in 9317A2. You can read it. It's again one of those provisions of Article 9 which I think are not drafted all that clearly. I think you guys and I could draft it better, but we won't criticize. It's a beautiful article, but I'll tell you what it means. Is that if you have a contest between a lien creditor and an unperfected secured party, the lien creditor will win. A secured party only defeats the lien creditor if it's perfected before the lien creditor arises. And I'll say that again. If you have a contest between a unperfected secured party and a lien creditor, the lien creditor will win. The secured party only defeats a lien creditor if the secured party is perfected before the lien creditor arises. That is, before the lien creditor converts its claim, its court claim, its judgment into a writ of execution to actually have a right to the collateral. And when that happens, when that lien creditor arises, when that party converts a claim into a right to get at the collateral, that's a matter of civil procedure and a state law that we won't delve into. And I wouldn't test that. I'll make it clear in an exam, and the bar exam makes that clear as well. Okay, so Martin's wins. Martin's Travel Service wins in that first question because they are a lien creditor, and Octopus National Bank was unperfected. That's why you got to file a financing statement and get it done. Otherwise, your client loses. Okay, so now. And you should look at the definition of lien creditor in 9102A52. Now the next question is, if instead of a judgment creditor seizing the good, Epstein's bookstore had filed a bankruptcy petition against Octopus National Bank's lien, while Octopus National Bank's lien was still unperfected, what is the result? Okay, so now we have, instead of this judgment creditor, this lien creditor, being involved in the contest, now we have Epstein's bookstore filing a bankruptcy petition. So now they go into bankruptcy, and what happens when you go into bankruptcy? But the bankruptcy trustee, a trustee in bankruptcy, is appointed, who implements this automatic stay, protecting all of the assets of the debtor. And then you have the contest then between the trustee in bankruptcy, who wants to protect all the assets, and the secured party, here Octopus National Bank, that wants to get at the assets. And who wins? And again, the trustee in bankruptcy, if you look at the definition, is a lien creditor. So the result is the same with respect as was the case with Martin's Travel Service. The secured party loses unless it was perfected before the lien creditor arose. And so here we have the lien creditor's bankruptcy and trustee arising when they file a bankruptcy position. And Octopus National Bank is unperfected, so they lose to the trustee in bankruptcy, which means Octopus National Bank can't get at the assets. Bankruptcy trustee is going to be able to hold on to them and protect them from the efforts of Octopus National Bank. So now Octopus, because whoever the lawyer was, has failed to file the financing statement, loses against Martin's, loses against the trustee in bankruptcy. You got to file that financing statement or perfect in some other way. Final question on problem 62. What result if instead Epstein's bookstore has sold the inventory to a good faith buyer? Okay. Well, we're learning a lot in this rule. These are in this problem. These are very important rules. We've learned so far the rule of, in two different ways, the rule of a secured party versus a lien creditor. The secured party is going to lose if unperfected. And now, the question is we have a secured party versus a buyer. And the rule there is that, again, the buyer is going to win if the secured party is not perfected. Again, it's so important to perfect because you get your client protection against lien creditors of all kinds and against buyers of the collateral, not of all kinds. A buyer in the ordinary course of business is going to defeat the secured party, but here we just have a regular buyer. Let's assume. We don't have much information here. But I suppose it's another bookstore. It's not someone going into the bookstore and buying a few books. It's another business buying the entire inventory. And so it's not a buyer in the ordinary course of business, but another company. Just a regular buyer, we'll call them. So what is the rule there? It has a little twist to it. The core of it is that the buyer wins if the secured party is not perfected. But the buyer can also lose. The buyer can lose, one, if the secured party is perfected before the sale. But the buyer will also lose if the buyer has knowledge of the security interest before the sale or upon the sale. So keep those two items in mind. In order for the buyer to win, to state it another way, in order for a buyer to win, the buyer cannot have knowledge of the security interests, and the secured party cannot be perfected. That's the end of problem 62. I will see you in the next video.